Welcome to the afternoon session of the Court of Appeals. I'm Judge Arnold Golden from Memphis, and joining me today on the panel are Judge Kenny Armstrong from Memphis and Judge Karma McGee from Savannah. Ms. Tiffany, would you please call the case?
Stephen Kampmeyer et al. Versus State of Tennessee.
Mr. Gilreath? You're mute. You need to push your unmute on.
I'm too old. I got it now, right?
You got it. You got it. And you need to let us know whether you want to reserve any time for rebuttal.
2 minutes, Your Honor.
All right, sir. 2 minutes. You may proceed.
May it please the court, this case involves a matter before the Tennessee Claims Commission. The plaintiff is a fellow from Florida who had a serious accident when he ran into a state of Tennessee work truck vehicle that did not have warning procedures. He had a serious injury. He filed a case before the claims administration with the proper form, or the form that they gave him. His wife inadvertently her name was not on the form, and she didn't sign it. So before the statute ran, we filed a complaint for him and his wife, including his wife, in which we alleged the facts of the accident as indicated were on the same facts that were on the claim form. So the commissioner dismissed her claim with prejudice because she had not filed the notice before the statute ran. We did file the complaint before the statute ran. So our plea here is that we'd like to do what was done in the Hunter case and not have a strict rule here, but allow her claim to go forward as an inadvertent part on her part for not signing or not giving the notice to the claims administrator. The Hunter case is directly in point. It's a case that my friend Jerry Summers handled, and in which the plaintiff in that case did not file her administrative claim, but filed a suit in the Claims Commission. And they treated, even since it was filed before the statute, they treated it as notice because it contained all of the facts of the accident, treated it as notice and allowed it to go forward. The notice requirement in the statute says that it shall include the State Department, the board, the institution, the agency, the commission, and the facts of the injury, how it happened, the witnesses, and so forth. The complaint in this case contained all of those facts. And in looking at the notice that is provided by the claims administration, it doesn't have a place on the notice for the widow or the wife to sign or to include. It doesn't have a place for her to put her name, except I guess you could put it in the same box as her husband, or I guess you could file a separate notice, which was not done, but it's a little bit ambiguous. So we just feel like that we should have substance here over form, and that the claim should be deemed as filed as shown in the Hunter case. Uh, the defendants, seems like their main thrust is that they didn't have a chance to investigate her claim. Her claim, she was in Florida, and when the accident, he was here when the accident occurred, and his form, though, not only lays out the facts of the accident, but the witnesses, their phone numbers, the accident report was attached, and so they had everything about the accident that they needed. They just didn't have her loss of consortium claim. So that's our case, Your Honor.
That is a separate and distinct claim, isn't it, from the husband's claim?
It has been so held, yes.
Well, how do you, looking at, I know you've got the Hunter case that you cite, but looking at the statute, doesn't the statute say that filing a written notice is a condition precedent to recovery? And then in subsection B, it says the claim is barred if you don't file the notice. How do we get around that?
The only way to get around it is that the notice is in the complaint that was filed before the statute. In other words, it doesn't say the notice. The statute doesn't say the notice has to be on some form that the state provides. It just says a notice. So we contend.
But the notice is filed with the division's claims administration, not with the claims commission, right?
Well, the Hunter case indicated that they have the same address. They're the same place. They're at 502 Dedrick Street. But you're right, it does say what it says, but we feel like that there was a notice. The notice was given, although it's not in the form as they'd like.
Let me ask you, is the current version of TCA 9-8-402, is that different now than when the Hunter case was decided?
I don't believe it is.
Do you know whether it's different or not?
I don't know. I don't.
Okay.
Joey, do you have anything further? You still have your rebuttal time.
No, I don't have anything further.
All right. Thank you very much. Ms. Murphy? You're mute. You're mute.
I knew I was going to forget. Thank you. May it please the court, I'm Megan Murphy on behalf of the state of Tennessee. It is well settled that the state of Tennessee is immune from suit except in such manner and in such courts as the legislature has determined. Since the state cannot be sued in its own courts without its consent, any statutes that permit such suits must be strictly construed. And any actions brought against the state can only be brought in such courts and under such conditions as have been specified by the legislature. In Tennessee, the Claims Commission Act was enacted to allow certain actions against the state, such as the action brought by Mr. Kampmeyer for personal injuries due to the alleged negligence of state employee in the operation of his vehicle. That act specifically lists the claims that are permissible against the state and explains how the claims must be presented. It requires that any party bringing a claim against the state must give written notice of the claim to the Division of Claims and Risk Management as a condition precedent to recovery. And we've referred to the Division of Claims and Risk Management throughout our briefing as the Division of Claims Administration, just because that's how it's been done. Claims Commission briefing, and then the order of the commissioner also referred to the Division of Claims Administration. So just for continuity, I'll be referring to it as the Division of Claims Administration. The Claims Commission Act states that a claim is barred unless such notice is given within the time provided by the applicable statute of limitations, which is 1 year in this instance. The notice requirement is meant to give the Division of Claims Administration time to investigate the claim and decide whether the division should go ahead and honor it without litigation. If they are not able to do so within the statutory 90-day settlement period, only does the claim transfer to the Claims Commission? It is undisputed in this case that Melissa Kampmeyer did not give notice of her claim to the Division of Claims Administration prior to inserting her claim into her husband's Claims Commission complaint. Therefore, she did not satisfy the condition precedent to recovery, and pursuant to the clear language of the statute, her claim is barred. In their briefing, the appellant presented two arguments as to why her claim should survive in spite of her failure to give written notice according to the statutory requirements. The first, which Mr. Gilreath did not touch on here, is that they claimed that her claim should have just been transferred to the Board of Claims under Tennessee Statute 9-8-402A5 and not dismissed. But the statute cited does not apply in this case. The statute provides that claims not within the jurisdiction of the Claims Commission shall be sent to the Board of Claims. The Board of Claims is not the same entity as the Division of Claims Administration, where the written notice was required to be made by Mrs. Kampmeyer. The Board of Claims is comprised of commissioners of different agencies who can investigate and hear certain claims against the state and can agree to pay certain civil judgments against state employees. The Board of Claims statute specifically states that the board has authority to investigate and hear claims and make awards in cases based on acts or omissions of state officers or employees where the claim does not fall within the jurisdiction of the Claims Commission. It goes on to say that the Board of Claims shall not have jurisdiction over any claim arising under statute Tennessee Code 9-8-307A, which is the Claims Commission statute that gives the Claims Commission subject matter jurisdiction over certain claims, including the claim here that Mr. Kampmeyer's claim for personal injuries due to the negligent operation of a vehicle by a state employee. So in certain types of cases defined in the Board of Claims statute that do not fall under the subject matter jurisdiction of the Claims Commission, the Board of Claims has some authority to hear cases and make awards. As the Claims Commission Act states, the Claims Commission has exclusive jurisdiction to adjudicate. Adjudicate. Do you have a question? I'm sorry.
No, you're good.
Okay. It has some authority to hear cases and make awards. But as the Claims Commission Act states, the Claims Commission has exclusive jurisdiction to adjudicate those causes of actions over which it has subject matter jurisdiction. Thus, the Board of Claims is inapplicable to this case entirely. The appellant's second argument is that the filing of the complaint in the Claims Commission within the statute of limitations should have been sufficient to give written notice to the Division of Claims Administration in light of the unreported 1993 case of Hunter versus State. But their argument cannot prevail for two separate reasons. First, subsequent case law has effectively nullified the finding in Hunter that the Division of Claims Administration was but an extension or adjunct of the Claims Commission, which the Hunter court relied upon in making its determination. In Moreno versus the City of Clarksville, a 2015 published opinion, the Supreme Court had cause to analyze the purpose of each of the Division of Claims Administration and the Claims Commission as set out in the Claims Commission Act. Rather than upholding the finding in Hunter that the Division of Claims Administration is a mere extension of the Claims Commission, the court in Moreno determined instead that the Claims Commission Act structure was purposefully created to allow the state an opportunity to resolve a claim administratively without the need of a lawsuit. The written notice to the Division of Claims Administration and a complaint filed in the Claims Commission serve different functions. The written notice to the Division of Claims Administration triggers a protected 90-day settlement period during which claims can be resolved without litigation. Only if the claim is not resolved during the 90-day period does the claimant have the ability to adjudicate the claim by filing a formal complaint in the Claims Commission. The Moreno analysis makes it clear that the Division of Claims Administration and the Claims Commission are different entities with separate and purposefully delineated functions. The Division of Claims Administration to try and resolve claims prior to litigation, and the Claims Commission to adjudicate claims that the Division of Claims Administration is unable to resolve. By inserting her claim for the first time into her husband's complaint, Mrs. Kampmeyer deprived the state of the protected 90-day settlement opportunity, and pursuant to the statute, her claim is barred. The second reason the Hunter decision should not be applied to this case is because the relevant facts are distinguishable. In Hunter, there was only one claimant who mistakenly mailed her complaint directly to the Claims Commission within the statute of limitations. Evidence in that record showed that in 1993, it was common practice for the Claims Commission to transfer to the Division of Claims Administration written notices of claims that had been mistakenly sent to the Claims Commission. There is no such evidence in this case, and appellant has not disputed that the written notice was never transferred to the Division of Claims Administration. In Hunter, unlike here, the Claims Commission did transfer the entire case to the Division of Claims Administration, and it was received in the Division of Claims Administration 4 days later, which happened to be after the statute of limitations had run. Here, Mrs. Kampmeyer did not mistakenly provide written notice in the Claims Commission. She simply added her claims to her husband's already existing and properly filed complaint. Based on the foregoing and the state's submitted brief, it is the state's position that Mrs. Kampmeyer did not satisfy the condition precedent of providing written notice of her claim with the Division of Claims Administration within the statute of limitations, and as such, her claim is barred, consistent with the language of the Claims Commission Act. Thank you for your time.
Any questions? Thank you, Ms. Murphy. Mr. Gilreath, you have 2 minutes in rebuttal.
Her argument seems to be that the state was deprived of a chance to investigate her claim. The state was not deprived of anything, because the only thing that they were deprived of is hearing what her loss consortium claim was when although she was in Florida when the accident happened. The notice that was given previously by him contained all of the facts of the case. They never, even though they transferred that, they never even did anything to investigate or notify him of it. And it's been over a year since they transferred it. So they haven't suffered any loss in this case. They haven't been prejudiced in any way. And I think that makes a difference. Thank you.
Thank you very much. We'll endeavor to get you an opinion as soon as possible. Thank you very much for your argument.
Thank you.
This honorable court is now in recess, or